Any health-related information on the following show provides general information only. Content presented on any show, by any host, or by any guest should not be substituted for a doctor's advice. Always consult your physician before you begin any new diet, exercise, or training program. And thank you for listening to the Whole Care Network.
Welcome to Healing Ties on the Whole Care Network. On Healing Ties, we're creating a life to love after caregiving ends by sharing stories and resources and being with awesome people like you. Now that caregiving has ended, let the Healing Ties begin. Here's your host, Chris McClellan, the Bow Tie Guy.
Well, greetings, everyone. It is Chris McClellan, the Bow Tie Guy, for our second episode in our Candid Conversations About Care with Amanda Singleton. Amanda, great to see you again.
Great to see you, too. Thank you for having me.
Yeah, so just before we get into our conversation today about the documents, the legal documents, just remind our listeners a little bit about your background and your firm here in St. Petersburg.
My firm is Singleton Legal. I go by the Caregiver Lawyer. You can find me on Twitter and Facebook and LinkedIn and just everywhere you could possibly be on the internet. Singleton Legal has a presence as the Caregiver Lawyer or at Singleton Legal. I am a multi-time caregiver, and as far as I know, the only caregiver lawyer in the area, and my firm does advocacy for caregivers across the lifespan, people with chronic illnesses, conditions, aging, and special needs. And we are so happy to be doing this podcast.
Oh, it's exciting.
It gives me, it is exciting, and it gives me a way to sort of do what I do on a one-to-one basis, with my clients and have a broader reach. So what we're going to talk about today is almost the first question after I tell people just to tell me their story and how they arrived in my office, and that is, what documents do you have in place? What
documents do you need? And we know that you practice here in Florida. Not all documents are universal, but they all apply in different ways. For instance, one of the examples that I learned through my caregiving experience with Richard when we lived in Missouri, the laws were different.
They are. So what was your experience? What did you have to redo, or what wall did you hit?
We needed to redo the healthcare proxy because the terminologies were different.
That's right.
And what I learned in the process, and we'll get into all the nitty-gritty of all the documents that are needed. And we're right in the middle of season right now. All the different snowbirds, people who have homes in other states, might be even a good practice to have your healthcare surrogates written up in both states because
I think it's a great idea because what is accepted in one state, although a legally valid document in one state is deemed legally valid in another state, practically you're going to run into some problems. You could. It may not. It's not a foregone conclusion, but it happens. And the terminologies are different. And I see this a lot with my snowbird clients or people who've relocated here and they say, "Oh, I don't need this. I have it." Well, let's take a look at it and see. And yes, so the terminology can be different. Proxy is a term that other states use here. They're more likely to be called a surrogate.
I just been educated.
You see durable powers of attorneys in some states that are very inclusive of medical directives. I don't do that. As an attorney, I separate them because I don't want a doctor knowing how I want my legal and financial affairs to go. So having said that, this is a general conversation, and I hope that it gets a conversation started in your family if you haven't had one, or it gets a conversation started for you if it's been a long time, or if you have changed circumstances. So And that's an important point to make, actually, before we get started. If you do this once, it's not done.
It's not done.
It's not done.
Laws change.
Laws change. And these are literally living documents, and I want people to think of them that way. Mm-hmm. Every couple years, take them out and look at them and say, does this still align with what I want? Did my surrogate move away? Have they passed away? Right. Do I need to name someone new? Did we have a fight and I don't like them anymore? All these things can
family
happen.
Family baggage. So I heard a line here recently. I think you'll appreciate. where there's a will, there's a relative.
Oh, you took my line.
And that wasn't even scripted.
That's right. And that's so funny. Where there's a will, there's a relative. And a lot of this that we're talking about is empowering. It's not something to be afraid of. It is something where you are maintaining control over your life and being the authority on your wishes. And that is powerful. In addition to that, when you do these documents, you're giving a gift to your family that they don't have to make decisions for you and speculate what you would want. And on what we discussed in our first episode, communication is essential.
Communication is essential, and I think back to as you were sharing your story about your mom, where you just received that phone call, and all of a sudden you were thrust into the role of a caregiver, and how many there's examples of like that just all over the country. Right. But I think the follow-up question that I didn't ask last week that it's appropriate to ask this week was, did your mom have her documents in order? That's
a great question, and I want to know the same about Richard.
Yes.
You may not be able to hear me banging my head on the desk right now. No, not really. I'm not banging my head on the desk, but I will share that I wanted to bang my head on the desk for a lot of the time when I was taking care of my mom, Cookie. So I related that she had just been in Europe when she got diagnosed, and part of her thing when she traveled was she would give me a list of all of her accounts and where she had them and her passwords. And she would also give me her healthcare surrogate and her living will. In case anything happened to her, I would be able to come in and receive her medical information and make medical decisions for her. She used online forms. The lawyer's mother used online forms, and she used LegalZoom to make her will, which we'll talk about later. We're not going to talk about wills today. We are just going to talk about life care documents. Anything that's post-life, trusts, wills, property work, we can't even touch that, but we do want to talk about what happens with you with a medical crisis and at end of life. So my mom did have her healthcare surrogate and living will, so it made it very easy for me. When I rushed to the hospital that day, I had those documents in my hand because I had them on the desk, just in case, with that little list of accounts.
Right.
And what she didn't have, and we'll get there. It's the third part of a sort of a three-part conversation we're going to have. She did not have a durable power of attorney. And what a durable power of attorney does is it names someone who can handle your legal and financial affairs if you cannot. And so, when my mom came home from rehab after brain surgery, and I was trying to pay her Duke Energy bill and talk to her mortgage company and do all that, none of them would talk to me. They said, well, we have to talk to her, put her on the phone. She can't speak. She lost her voice. Well, there's nothing I can do for you, ma'am. I'm sorry. Click. So I had to get a durable power of attorney lickety-split so that I could really keep the gears turning for her life. And that is what is so critical about these documents. So we've talked about state laws vary. This is a general discussion. Not legal advice.
Right.
Consider this the first step towards handling this for yourself if you're listening to this today and you don't have it done. I think we should move into why advance directives.
Yes.
What are advance directives?
Yes, very much so.
When you hear the term advance directive, that means it is a statement about how you want your life to go if you cannot speak for yourself. And they name the person who can carry that out. So that is the plain English explanation of an advance directive.
I would really just like to talk very candidly here on this topic because oftentimes it comes back to communication. Oftentimes, it's hard to have these conversations between parents, between siblings, between family members, between caregiver and parents, but it's essential to have these conversations because when you're in the middle of a crisis and you can go to this document and you can follow everything that person wants, the peace of mind that I had as a caregiver, because I was fortunate, I knew exactly what Richard wanted. And I didn't have to worry about making a decision I had to speculate on whether or not he wanted this or that. I knew exactly what he wanted because we had those documents in place. I'm always saddened when I talk to people across the country who all of a sudden they got that phone call just like you got, and they didn't know what to do. They're having these conversations with their loved one in the ambulance on the way to the...
Right. And nobody's in their right mind.
And nobody is in it. They're totally in crisis mode.
Right.
And to have these delicate, life-altering conversations in crisis mode, it's not good for any of us.
No, it's not. And people can be medicated or on a big adrenaline high or whatever, and not be as lucid and competent as they would be if they are thinking about it in advance. And these are tough conversations, and they require a lot of introspection, and they require a pretty heavy analysis of your spirituality, your values.
Oh, yes.
And yes.
Very much so.
And people get very uncomfortable with them, right, and dismissive. And that's where it's our job as caregiver advocates or attorneys or someone who's been in the shoes of a caregiver before to put it out there and to make these not taboo subjects or forbidden subjects. And I will say I am not 100% successful with this. I have family members and friends that I try to talk to about it, and I still get the shutdown. And that's okay. I mean, one step at a time. Just even considering it is great. What I find helps is when you explain the alternative to people.
Right.
What happens if you don't do this? What are you leaving to chance? In Florida, the mechanism that we use legally, if someone has not done advance directives, if we don't know their wishes, generally a person will have to apply for a guardianship. And that is a court process. And it costs money and it costs time, and there is accounting to the court, and it's a pain in the neck, and it's preventable by doing advance directives.
Right, advance directive, sure.
Right. We talk about Terri Schiavo.
That is such a excellent example.
It is. It's been a few years now since she passed. She passed in 2005. And for those who are not familiar with Terri Schiavo, this woman at the age of 28 collapsed in her home in St. Petersburg, Florida. And over a period of 15 years, her family went back and forth about whether she would be permitted to be removed from life-prolonging procedures. So that's artificial hydration and nutrition. And they had different opinions. And it's so important to say, nobody is wrong. Nobody is wrong here. They just didn't know what she wanted, and they disagreed. And the lawyers and the judges and everyone involved in this did such a beautiful job advocating. But in the meantime, this woman could not speak for herself. And she would have been able to if she had done these documents.
It's the documents that give you the voice.
That's right. And it's so harrowing to think that this is a preventable thing. All of that heartache, all of that time and pain. And just by way of relating this personally, I was in 5th grade when that woman collapsed. The litigation was ramping up when I was in college and doing my death and dying studies, so I was following it very closely. She passed away just a few miles from my law school 2 weeks before I graduated. And so I went from being a child to being a licensed attorney, and well, I'm not licensed, a graduate of a law school, in the time that all of this played out. And because of this, her legacy and her gift to the world in a lot of ways is that it brought advanced directives and end-of-life planning very much to the forefront. Right. And now, even, I guess, 13 years later, it still is such an illustrative example for me when I talk to people, because people from here, people in Florida, really remember that case. And when I say, this is why it happened, their faces drop and they say, I do not want that to happen to me. and we say, great. So here are the documents you need. That really opens up the door. It opens minds, I think, a little bit.
So let's kind of go through the step-by-step process. So documents are needed. Is there a rule of thumb on what needs to come first?
No, nothing about what comes first, but I like to start with the medical documents.
Okay.
I do sister documents. I do the healthcare surrogate.
Okay.
And the living will. And before I go on, I want to empower people. You do not need to see an attorney to do these documents. There are many fine online ones that you can use that are valid in your state. I will give you resources at the end of our conversation that you can go on and look for yourself. Just make sure that when you sign them, you do it in accordance with your state law. The form should tell you how to do it. If it's a holdup that you don't want to see an attorney, you do not need one. Just get it done. And if you tweet me at singletonlegal.com, or if you just even email my firm info@singletonlegal.com and you're in Florida, I will send you a healthcare surrogate form. Just please do it. So
that's how important it is.
That's how important it is. And I really don't charge my clients to do them if that's all that they're doing. It's my preference that people just get it done. So, healthcare surrogate. What that form does, it names a person who can receive your medical information and make medical decisions for you in the event you cannot. So, if we signed one today and I named you, Chris, my healthcare surrogate, you would not be able, unless I specified that you could, to call my doctor and say, let's tinker with Amanda's, cholesterol medication, which I don't take. But you can't do that today. That's not the way it works. You have to be in a place of incapacity. Mm-hmm. The way that I do my form is you can make it effective today, but they're called a springing document. They only spring into effect if and when you are at the place that you cannot provide informed consent yourself. So who's a good surrogate? This is a conversation that needs to be had. The best surrogate is someone who's going to follow your wishes, and so you need to talk to them about what you want. Are they receptive to that information?
It comes back to that It comes back to that communication component.
It does, and you need to be able to talk to them about it and assess whether they will be able to bifurcate what they think from what you think, and that's a big piece. They have to be an adult. And they shouldn't be your healthcare provider, because your healthcare provider has a natural conflict right there, or an employee of your healthcare provider. So that's what I recommend. You can name alternates. You can name co-surrogates. People get really sticky about offending family members if they have multiple children, and maybe they're all here. Maybe they all live in the same area. They don't want to hurt someone's feelings by naming someone else first. That's fine. We can work with that. We can change the documents, but don't let those feelings of family conflict stop you from doing it. Right. And never assume that everyone is going to agree, because people say, oh, well, the kids will figure it out. No, they won't.
No, they won't.
No, they won't. And so that's crucial. But you can absolutely name surrogates in order. You can have, first, I would like Chris. If Chris is unavailable or unwilling to do it, then I name Chris's sister. Mm-hmm. And that is so important to have alternates, because people can be out of the country.
They could be ill themselves.
That's right. Circumstances change. Life changes. So that's the deal with the healthcare surrogate. And it's not an end-of-life document. It's at any time of incapacity. Right. So the living will, that is your end-of-life document. And the way that I write them is, if a person is in a persistent vegetative state, an end-stage condition, or a terminal condition, and there is no medical probability that they would go on living without the intervention of life-prolonging procedures. So life-prolonging things are not things that are going to save your life. It's not that you're going to miss out on a surgery that's going to fix everything. This is what we've been talking about, like with Terry Schiavo, artificial hydration and nutrition, breathing machines that can keep people alive indefinitely. And some people want to be kept alive indefinitely, and that's their right too.
That's their right. It just needs to be documented.
It just needs to be documented. Just say what you want. And people say, well, who makes that decision? Your medical providers do, and it's confirmed, and it's rechecked. It's not a capricious decision that is made. And there's a very gross term that people use all the time. I don't like it. Pulling the plug.
Oh,
right?
Goodness,
you know, and that's they come into the office and they say, if I'm in that place, just pull the plug, Beverly. You know, and that conversation happens in my office a lot. What this does, your family doesn't have to make the decision to pull the plug. The medical providers say, this living will is in place. This is what this person wanted. And so now we are going to discontinue life-prolonging procedures. Palliative care is still given. Comfort care is still given. People do not pass in pain. And that is important to note.
It's dying with dignity.
It is dying with dignity. I agree.
Think back to my experience, and I was fortunate enough to have an open conversation with Richard. I knew exactly what he wanted, especially as it got close to end of life. I didn't have to worry or speculate about what he wanted because we had that conversation. And I just like to encourage everybody that's listening is to find that comfort zone in communicating with the person that you're caring for, because it's important that you know what they want so that you can direct the people, the third parties that are involved in your care. You might remember in our story, I used to carry around a green folder everywhere I went.
Yes.
Because, as a same-sex couple, the rules, this was before marriage equality, the rules were a little bit different. That being said, it's also important to note that whether you're a same-sex couple or a heterosexual couple, if you're unmarried, you have to have these documents, the I's dotted and the T's crossed, because in every state of the country, your next of kin is the spouse.
That's right.
And if you don't have these properly documented, you're just going to run into tons and tons of problems at the most inopportune time.
Right. When things are at their most high level of stress, and then it just throws kerosene on the fire. And there's so much that we can do with these too. There are mental illness directives. There are directives for people with dementia diagnosis, where they can expect cognitive decline over a period of years. There are religion-specific advanced directives.
Sure.
And that's wonderful. Because people do want to be in compliance with their faith.
Right.
And we can do that. Another thing about the living wills, and this is just huge, your living will can discuss your organ and tissue donation. And is that close to your heart?
That's close to my heart, yes. It's very important. Can I jump in on the attorney here and give a precise example why this is important?
Yes, please.
So, Richard donated his remains to a organization that did specific, their research was specific to tissue research. When the will was drawn up, the will was written as a body donation for medical purpose.
And it didn't specify
didn't specify tissue. So medical donation and tissue donation to a common person like myself might mean the same, but when you get into cremation that is obviously irreversible, those medical terms mean something very different. And so since I'm not going to place any blame here on anybody, but since we weren't informed about the precise wording of what that donation entailed, his donation was denied an hour and a half after his death. Luckily, that all got rectified 48 hours later. But when you're in the middle of these conversations, especially when it's stressful, and when a life transitions, you just want to ensure that the documents say exactly what you want and what you mean. And that's why it's important not only to have that conversation with the person that you're caring for, but with your attorney as well. And I would assume that you would probably would agree with this. One of your best clients is going to be a client that's informed, that they know what they want.
That's right.
And that's why it's important, at least for me, to have these open conversations, that because I don't want somebody to go through what I went through. And I certainly wouldn't want any family to go through what Terry Schiavo's family went through.
Neither do I. And I'll relate. Our friend who was in end-stage renal failure, he was young. He was very young. He was 34. And we hadn't seen him in years. And his girlfriend called. She said, he's in the hospital. Will you come see us? And he was in such pain because the hospital would not give him pain medication. Liability. And so they sent him home. And I said, do you have anything in place? And he said, no. And I said, have you called hospice? And they said, we don't really even know what that is or what they do. And I said, okay, I do. Do you mind if I call them? And within an hour, hospice had sent someone out to do an intake evaluation. And the nurse was phenomenal because she said, are you in pain? And he said, yes. And she said, you don't have to be in pain, honey.
You don't have to be in pain.
And by that evening, he was receiving comfort care. But in the final weeks, short weeks of his life, because he did not have his documents done, his girlfriend was legally nothing. She had no standing to direct his care and do what she knew he wanted, but she had no standing. That was tragic to watch the whole thing unfold. And
how frustrating.
So frustrating. And I was just, a little removed, and just there to help. So, but I couldn't intervene. There was really nothing at that point that I could do as a friend or a lawyer, but try to calm tempers and allow him to pass peacefully.
With dignity.
With dignity.
So we just got a couple of minutes left. I know we've just gone through just a plethora of information today, very important, and I know we probably not got to everything.
We did not.
But let's kind of recap here just real quickly. What are the important documents?
Medical directives, healthcare surrogate and living will. Legal and financial directive, durable power of attorney. Do not do these on your own, please. These are nuanced and complicated documents in the state of Florida, and I expect throughout the rest of the nation. Please, 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 please consider what you're doing if you are going to use an online form with these, because about once a week I see someone who did one, and that's great, but we can't actually use it because it doesn't say the words we need it to say, much like the story you just told me.
Right.
Or it's not going to be accepted by a bank here. In the state of Florida, in 2011, we had a big law change on durable powers of attorney. You know this.
I do know
right?
this.
You were in your period of time of caregiving then. So one that predates 2011, it's not invalid, but you just, it may not be worth the paper that it's written on,
right? Because
no one will take it. So no, it won't be accepted by a bank or a, someone you're trying to do a transaction with. So if you have an old one, please update it. If you haven't done one, please consider it. These are powerful, important documents. They name someone who can handle your financial and legal affairs. They're not a springing document. They're effective the day you sign them. So when you name someone on this, it better be someone you trust, and keep that document to yourself. Keep it a little close to the vest. If you've utilized an attorney, you can tell your attorney the conditions under which you want that document released. Right. There's an added layer of protection for you there. Again, I do consider this to be a crucial document because it does prevent a guardianship. One thing we mentioned at the beginning, this talk does not talk about other parts of planning that you can do that you wouldn't need durable power of attorney, for example, trust work. But we could not possibly get into all of that with the conversation and the time that we have today. It's better than nothing.
Yes, this is informative.
It's informative.
Right.
Communication is key. Have the conversations, but also write it down.
Yeah.
And don't consider it a done deal. Revisit it occasionally and make sure it's all still in line with your life circumstances of today. 2
questions before we close today's session is, how often should people have their documents reviewed? I know the law changed here in Florida in 2011. What's kind of the rule of thumb?
I think once a year you should pull them out and see what you did. And I like to give clients a one-pager with just bullet points so they can see who they named and what they did. Just make it a part of your annual tasks and don't neglect it. Try not to forget about them. It's pretty easy too, but you don't need an attorney always to do this. So, take the power into your hands and be responsible for it, because this is some of the most important moments of your life are relative to your passing. And people don't think of it that way, but truly this is a part of life.
And access to the documents. I'm a big believer in technology, but I also believe that the safest document is one that's printed. Always have a printed document on hand, a jump drive. There's different systems out there that will house your documents.
Right.
But it's so important to have a hard copy of your document.
Have a hard copy. Copies are accepted in Florida of the documents we're talking about, but have them stored electronically too. For example, my firm keeps copies in our cloud so that if someone's house burns down, people can't put their hands on things. There's a little element of protection there. But also, with your medical directives, give them away. Copies. And give them to your doctor, give them to your surrogates, tell them what you want, and give them an electronic copy, because when you are rushing to the hospital, maybe you don't have time to go back and grab the file. Maybe you don't have time to go to the safety deposit box or your fire safe, but you are always able to pull up something out of your Google Drive or just an email you send yourself.
And the one tip that I'll have, and I'll be interested to see how you feel about it, keep a hard copy in your car.
Aside from the fact that if there's personal information on it, I don't like the idea of keeping anything with too personal of information in a car. We had like a rash of break-ins in our area, so I'm vigilant. But it's not a bad idea. Yeah.
So, Amanda, to let our listeners know how they can touch base with you and all the great resources you have at Singleton Legal. Singleton
Legal, you can find us at the Caregiver Lawyer at Singleton Legal, www.singletonlegal.com. You can always email me if you have any questions, amanda@singletonlegal.com. If you'd like a copy of a Florida-compliant healthcare surrogate, you can email info at singletonlegal.com. Also, I recommend you look into the AARP website. Has wonderful resources for the documents we talked about today. The American Bar Association, ABA.org, and the FloridaBar.org are all wonderful places to find this. You can also ask your House of Faith if they have documents that are appropriate for you. And please feel free to email with any questions about this show, because it is so critical to me that everyone has these done.
We really did have a candid conversation about legal care today.
Didn't we?
Yeah. Well, goodness, next week, Amanda, we're going to be talking about caregiver debt, and I can certainly personalize that conversation. But thank you for this terrific conversation today about an important component of caregiving that often goes unsaid.
Thank you, Chris.
Okay, well, that does it for this episode of our 6th series podcast, Candid Conversation About Care. Next week, we are going to be talking about caregiver debt. I'm Chris McClellan, the Bowtie Guy. I'm creating a life to love after caregiving ends through radio, writing, travel, advocacy, and being with awesome people like Amanda Singleton. Healing Ties is a part of the Whole Care Network. Check us out online at wholecarenetwork.com. We'll see you for another episode of Candid Conversations About Care next week. Bye-bye.